We need to talk about the rule of law. A podcast by Verfassungsblog and Deutscher Anwaltsverein. We need to talk about the procedural and organizational rules which shaped the judiciary. These rules are mostly made by ordinary legislation and rarely draw much public attention, seemingly rather technical and pedantic stuff for the most part, but at the same time hugely consequential for the rule of law. We need to talk about court packing. We need to talk about fiddling with the retirement age of judges. We also need to talk about the duration of proceedings and about limitation of liability in time, about judicial efficiency and effectiveness, and the corrosive consequences it has when people no longer with confidence seek justice in court because the court just won't deliver. I am Max Steinberg. We need to talk about the rule of law, a podcast by Verfassungsblog and the German Bar Association Deutscher Anwaltsverein. And our guests this week are András Baka, the former president of what was then known as the Hungarian Supreme Court, and before that, for 17 years, a judge at the European Court of Human Rights, and to my knowledge, the only former ECHR judge who has also a landmark decision of the Strasbourg Court to his name as plaintiff, which we will get back to in a minute. I will further talk to Maria Rosaria Guglielmi, a prosecutor in Italy and the vice president of the association Magistrats Européens pour la Démocratie et les Libertés, European Judges for Democracy and Freedom, MEDEL. And I will talk to Christoph Möllers, who is a professor of constitutional law and jurisprudence here at the Humboldt University in Berlin, and one of our most visible and esteemed public intellectuals in Germany. A very warm welcome to each of you.
Hello.
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 Judge Baka, 4 years ago, you won one of the most important cases about judicial independence before the European Court of Human Rights in Strasbourg, Baka v. Hungary. In a nutshell, what was that case about? What did the court decide? And what was the effect of this verdict in Hungary in general and on your judicial position in particular?
Well, thank you very much for the introduction and for the invitation also to be able to work with you. As far as the case is concerned, I think I never dreamed about to go back to Strasbourg as after being judge in Strasbourg and go back as an ordinary applicant. But unfortunately, I think the circumstances forced me to do that. And I think I wanted to show with this case what's going on and what's happening and what was the Hungarian situation and what is partly the Hungarian situation. I got elected for a period of 6 years in 2009. And I was dismissed from office as from January 2012. I served slightly more than 2.5 years. The situation was, which forced me to speak up for the judiciary and the judicial independence. I mean, I had several reasons for that. I had the power and I had the right and also the obligation to be able to comment the planned legislation of the government. And of course, there were several legislation steps which forced me to intervene. But I think probably the most important and the most well-known was the reduced retirement age of the judges. I mean, it was enacted to the transitional provisions of the new constitution, and which was adopted within 8 days without any consultation of the judiciary, without any consultation of either with me or the judicial council or any of the judges and organs of the judges. So it came, traditionally the retirement age of the judges were in Hungary 70 years old, 70 years, which was reduced to 62 within 8 years. Just imagine the situation that if somebody has a statutory possibility to retire at the age of 70 and within 8 days the legislation changes and reduced it by to 62. Well, this invoked enormous reactions among the judges. I mean, all judges, organizations, Supreme Court, other organizations like Council of Judges, and everyone was criticized, harshly criticized. I wrote a letter, an open letter to the Prime Minister on the day of the vote, in vain, and it was enacted. And of course, this was a very serious and probably one of the most harsh attack against any judiciary since the Second World War. And that was the first. It was not a hidden attack. It was quite obvious. Recently I read a book of the former president of the Supreme Court of the Netherlands concerning rule of law, and he said that he compared the situation to the Dutch situation when the German occupational forces occupied the Netherlands. They dismissed the president of the Supreme Court and also lowered the retirement age of the judges. The situation, of course, I mean, the means and the tools are similar. The historical situations are different, but nevertheless, they also filled in the vacant positions with with extreme rapidity, and that was an attempt to change the top level of the judiciary. Nearly 280 judges were affected. I mean, top-level judges, court leaders, court functionaries, or highly experienced judges. They had to leave. Of course, they were some of them. Only two were reinstated after the decision of the Court of Justice in Luxembourg. But nevertheless, it was a serious attack against the judiciary. So I criticize that, and I criticize other statutory arrangement, especially changing the structure of the judiciary and giving all the powers to the government, the parliamentary, the person who elected by the parliamentary majority, giving all the power to the president of the National Judicial Office. This was a major structural change, and I criticize that because this gave the power to one person with enormous power. She was the one who decided who would be the judge in Hungary and who is going to be promoted, and also she was able to allocate cases among courts, to take one case into another. So, I mean, I criticize also that. So as a consequence of all of this criticism, I don't want to go into the details because, I mean, it's not well known except about the early retirement of the judges. So I criticize that with my power, with my best intention. And I mean, I didn't express any political views. My approach was strictly professional. And as a consequence of that, I mean, the government enacted a new legislation, renamed the Supreme Court, and right now the Supreme Court is called Curia. And using this possibility, I mean, they pretended that the Curia is a new institution, and if the Curia is a new institution, the Curia needs a new president. A new president is needed to the Curia, and on this basis, I mean, a new president was elected because they added a new criteria to be a president, namely to be a president of the Curia, 5 years Hungarian judicial work was required, not counting my 17 years in Strasbourg, not counting that I was also a member of the Court of Appeal of Budapest. Well, and that's it.
So this was basically a deliberate attempt to get rid of you.
Yes, that was it. But I think, I mean, not my case is interesting in this situation. The case itself is very important, and I think the case was translated to several languages. I don't know how many, but around 20 languages. And the case is used as a university material in several universities. I mean, in the Netherlands, in Spain, in France, and several countries. And that was my intention, to point out that this is impossible to change the judges and to change the judiciary, no matter by what means, but in order to create a more loyal judiciary to the power and to the and also I think the court said a couple of important things in this case, especially when the court pointed out that the separation of powers has a growing importance nowadays, and also judges have the right to criticize or to be involved in and speak out, being able to speak out in matters which concerns judiciary. And I think it's a very important ruling of the court and a very important part of the judgment, entitling the judges to speak out, even if the questions of judiciary are having serious, sometimes political implications.
The decision has not been implemented in Hungary up until this day, right? I think the ministerial committee has only a few days ago renewed its...
That's right. That's absolutely right. I mean, as far as my personal satisfaction is concerned, I was paid. I got the amount what was awarded to me, but this is not important. What is important that in Hungary is still there are practices that judges who are speaking out or who are expressing opinions, I mean, they are punished for that, and that's why the Committee of Ministers, which is responsible for the implementation of the judgment, said that this hasn't been implemented. This part of the judgment hasn't been implemented.
I understand that currently the Hungarian government is about to try an maybe even more artful way to control who gets to be the president at the Curia, as the Supreme Court is now called. What is that about? What is going on?
I mean, if you followed what I said, I said that when they renamed the Curia, they inserted a new rule saying that it is a requirement to be elected as a president of the Curia to work in the judiciary in Hungary for 5 years, and international judicial work and other work didn't count. Right now they changed this rule, and they said that international judges and also constitutional court judges and their work and the candidates work as international judges or constitutional court judges counts. So it is included in the 5 years now. So when my case was decided, that I mean, my international judicial work was outside of this 5 years limit, because I worked less than 5 years as a judge in Hungary. Right now, they extended the scope of the conditions of the elections, saying that international judicial work and working on the constitutional court is included in the 5 years. And also there is another rule that it's never been, no one has ever been elected as president of the Supreme Court who was not a judge, who was not a member of the judiciary. So no matter for how long, all the presidents of the Supreme Court were for longer or shorter period member of the judiciary. And I think to be a judge, it is an attitude, it is a way of thinking. So you have to learn how to weigh the different arguments against each other. I mean, Right now, the new candidate to this position was Deputy Prosecutor General, close working mate of the present Prosecutor General. Worked 5 years at the Constitutional Court and had nothing to do with the judiciary, with the ordinary courts and with the judiciary. Never have had any kind of judicial work. I mean, being a constitutional judge, it's quite another task and quite another work. I mean, they are politically elected, more or less politically elected. They are very rarely dealing with individual cases. It is not like the European Court of Human Rights, dealing with individual cases, expressing, of course, more general views as well, but on the basis of the individual situation. Constitutional judges are in most of the countries, of course, not without exception, in Germany, in Spain, in the Czech Republic, and also in Hungary, they are dealing with certain number of individual cases as far as their constitutionality is concerned. So, well, right now the situation is like that. The new candidate of the President of the Republic was voted down by the National Judicial Council by a great majority, so 13-1. But well, I don't want to predict, but my estimation that he's going to be elected anyway, so it doesn't really matter. And a president has enormous power to allocate cases among the chambers, to create and to discontinue chambers, and put judges to different chambers, and to create parallel chambers, and so we don't have the automatic allocation of cases, which is, I think, would have been very important. Would be very important. Allocation of cases is crucial because it excludes maneuvering.
Thank you very much, Judge Guglielmi. We've talked about forced retirements. We've talked about early termination of judicial office terms of judges, and we've talked about the maneuvering of the current maneuvering of the Hungarian government. All of this as a strategy to clear the way for packing the court system with government loyalists, and now more than ever. Hungary was the first EU member state to try that strategy, but certainly not the last. Did the EU try to intervene, and if so, to which avail?
Thanks for the opportunity to bring you as well the perspective of Medal. The promotion of the rule of law and the independence of the judiciary as an important aspect of the rule of law is a part of our core mandate. And from the standpoint of Medal, I can say that the challenges for the rule of law, unfortunately, cannot any longer be reduced to the point of the formal guarantees of independence of the judges, because the populist government apply indeed complex strategies to reduce the possibility that the legality of their policies is subject to judicial control without making direct inroads into judicial independence, but rather modifying elements of legal framework that regulate judicial work and procedure, the importance of which is less easily understood by the general public. And there are many variations of this strategy that is adapted to the specific feature of each legal system and exploits its weaknesses or build on pre-existing political debates. The most striking example is, of course, that of Poland, Hungary and Poland, where the distortion of ordinary procedural patterns is endless. We just can mention disciplinary proceedings for judges who apply the decision of the European Court of Justice, or the refusal of the publication of the decision of the Constitutional Tribunal in the official journal, or the introduction of a special appeal procedure before a political appointed court for the revision of final judgments delivered in the last 20 years. The right to a fair trial and the rule of law in general are devoid of any substance when judicial decisions are not enforced. And all this disrupts, of course, the fundamentals of the rule of law, impacting on the certainty of law and fair trial, exceeding pressures on the adjudication process. This strategy is something apparently not yet at the same level of Turkey, where the annihilation of due process takes place with the dismissal en masse of judges and prosecutors without legal remedies, even after the end of the state of emergency, and with the harassment and mass arrest of lawyers and their persecution for alleged participation in the same activity of their clients. But nevertheless, this strategy is something which creates a deep fracture in generally accepted values and assumptions. And Medell carefully monitors all policies adopted by European governments that can be considered in their practical effect as court-passing exercises. The case we monitor, of course, very carefully are those well known of Hungary and Poland, and beyond the borders of the European Union, one cannot omit to observe that court-packing is one of the components of the rule of law dismantlement ongoing in Turkey. It's something that also predates the state of emergency, when in 2014 a new law was adopted to add new chambers and new members to the Court of Cassation and the Council of State. So when the law entered into force, the new High Council for Judges and Prosecutors, dominated by pro-government members, carried out the appointments with unusual speed. I think that we can enlarge the scope of monitoring beyond the situation where one observes judicial appointments tailored to have courts positively oriented towards the action of the executive power. In the perspective of making the judiciary a powerless branch of the state, one can reach significant results also by not appointing judges. I mean, leaving empty certain key positions or accepting to have several understaffed courts or understaffed prosecution offices. So also act on retirement age on positive ways, meaning postponing retirement can in some cases likewise give to the government majority a way to influence the composition of the court that have, for example, specific cases under adjudication. This was something under discussion, for instance, also in Italy a few years ago, when soon after the reform the welcome reform that reduced the retirement age, the government adopted a law decree to postpone the retirement age of the holders of a key position within the court of cassation. And it is probably to note also that there are situations when the rule of law can be jeopardized the other way around by the impossibility to have a judiciary in place. We can just mention the not often discussed situation of Albania that is currently facing a relevant constitutional crisis. The judicial reform in 2016, which created new institutions and promoted the re-evaluation process for all judges and prosecutors, the so-called vetting process, went too far from what's expected because the country does not have a functional constitutional court since 2018, and the Supreme Court has not operative for more than 1 year, and at the moment it has only 3 members out of 19. So this is a very complex situation.
Yes, obviously. Christoph Möllers, we've heard all these incidents, all these instances of legislative and executive attempts to tamper with judicial independence. To which extent would you say is leaving the judiciary alone a key feature of the rule of law?
Well, it very much depends on what you mean by leaving alone, obviously. I think one problem is generally that we can see many cases that we see some cases that are somehow clear, like Poland or Hungary, you have retroactive tampering of, people who are in place. But on the other hand, we see other cases in which we would assume that there is no mean political will behind something, but the structures are problematic too. I mean, we can say the CJU, for example, has renewal of the terms of judges. That is a problem of judicial independence. We have very powerful presidents in many courts. The CJU, again, would be an example. We have obviously many cases in which the structures and organizations are not ideal, though we would never assume that this is done for authoritarian reasons or, as a means of populism. It's just the way it is done. So that is a problem, to find general rules that make courts waterproof. And the second problem, obviously, is that courts somehow need some kind of legitimacy. So at least the appointment is always something very fragile, because the solution is not necessarily that judges can appoint themselves. When we have that in Spain, in a way, in Romania and other countries, and it's recommended by the Council of Europe, but the experience with that are quite mixed, actually. It leads to factionalism within the judiciary. It is somehow, judges become a case, somehow something very aloof. So I think judges, in even a well-functioning system, judges have to be appointed by someone else. So when we see that, I think we somehow have to look for some kind of core of judicial independence that is probably not really a problem of appointment. I think the judges have to be appointed, probably by political powers and in some or the other way. But of what judges do when they're actually in office and how they operate. And obviously there are things like defined terms, allocation of cases by general rules, depoliticization of the internal structure of the court, probably a peer equality between judges and not a presidentialization of the system. There are many things, I think, that could be recommended on more general terms. Which would not mean that the judiciary is an island. Still, I think one of the more sadder results of what we see in countries like Hungary and Poland is that, yes, what they did is probably a flagrant violation of the rule of law, retroactive, disciplinary chambers, all these things are clear cases. But then again, when we assume that PiS or Orban would be in office for 10, 15 years and somehow retirement kicks in and things are somehow going the usual way, well, they would have the power to reappoint judges, and this would somehow change the landscape. So one of the, I think, most disquieting factors we can observe is that you can actually appoint new persons with the same law and with the same procedural rules and get different results, which makes the whole idea of the rule of law a little bit, well, fuzzy, because you can see how much it is dependent actually on the actual persons who are working. And this, I think, leads to the final conclusion that what you actually need for appointment procedures is something like political pluralism. I think rules that somehow empower as many political actors as possible to somehow contribute to the appointment procedure, so that we don't have something like a monocratic structure, which only one party or one organ is capable of appointing all of them. But still, you know, this is something quite illusory given the well, the many fine techniques you can still have to influence judges who are in office.
We are talking about Europe, of course, but when we address the topic of court packing in these days, it's obviously on everybody's mind. On this very day, Trump's nominee for the Supreme Court, Amy Coney Barrett, and she'll be most likely confirmed, cementing a 6-3 right-wing majority in the court. And that in turn has stirred an intense debate about whether or not the Democrats, in the event of a victory on November 3rd, should pack the court to that right-wing majority. Is there such a thing as a good court packing scheme, Christoph Möller?
I don't think so. I must say, when we remember the Roosevelt days, 1936, when Roosevelt was considering this, having actually huge majorities in both houses of the Congress, even there it was very hard for him even to talk about that, not leaving alone to get a majority for that, for good reasons, because I think in the long run it would somehow deflate and devaluate the judiciary as a whole. You can do that, you know, and can get some kind of majority for perhaps a decade or so, but the institutional integrity of the whole thing is somehow blown apart by that. And therefore you don't really, you can achieve middle range aims with that, but you don't really secure the constitutional structure. I think the wiser thing to do is somehow to change the political landscape and the context in which the judges are operating. And that means, in a way, yes, in an informal manner, political pressure as a matter of what is the majority discourse, in order to tame them and to somehow get them beyond their own political agenda. But to pack the court would be detrimental for the court and would therefore be detrimental for the whole system. I don't think there is a beneficial court packing scheme.
Then again, there is such a thing as a captured court, and if there is such a thing as a captured court, one has to deal with the question what to do about it and how to reinstall it in its previous position. So I wouldn't want to argue that the US Supreme Court is there yet, but other courts, like for example the Polish Constitutional Court, certainly are. Now, Judge Bakker, what would your advice be in that situation? Do you think that the sort of hardball that these populist authoritarian regimes in Middle, Central, and Eastern Europe have played call for an equal strategy on the part of their opponents, or what would your advice be?
Well, thank you. First, I would like to react what Christoph said, and I quite agree with that. That the court system is not an island. It's not a separate area. It's not a separate territory. It's part of the system. It's part of every system, and of course, appointing judges, the politicians, and also well, the parliament has certain right, and this right is different from country to country, to appoint judges and to change the system and to improve the system. The problem is that the judiciary is never alone. It's an integral part of a system. Integral part of a system which based on legislation, executive and the judicial system. And of course, we can. I also agree with what you said about the U.S. Supreme Court and appointing a new judge. I don't see the U.S. system is different. It's much more political. I mean, judges could arrive to the judiciary after a political career. I mean, it happens very often, right? But even if, and being a conservative judge, it doesn't necessitate, being conservative means that in certain issues they are conservative, in certain other issues they are not so much. I mean, the best example that probably Antonin Scalia, who said that what really makes, what sets apart the US system from other countries, this is the separation of powers. So he didn't deny the very basic, the separation of powers. In Hungary, the situation is that there is no separation of powers. I mean, and if you take a look at the European scene, I mean, Parliament is sometimes very much against the government. I mean, just think about the Brexit. Many times the Parliament voted against the Prime Minister and against the solution what was suggested by the Prime Minister. Not talking about whether Brexit is good or bad. I'm just talking about that the system works. I mean, in Hungary and in Poland, the system is a unified system. It's a unified system, and the only different and a little bit separate part of it is the judiciary. And probably the judiciary is the only one who can, well, restore somehow the balance. But also we have to be very aware of that the judiciary is the weakest part of behind the parliament and the executive. Judiciary is the weakest. And without, and this is where I'm going back to your question, without outside help, it's impossible for the judiciary to win this fight, or at least equalize better this fight for occupying the whole judiciary and taking part of the system, like in the totalitarian states. So, well, I don't have the clue but I know that this is already a tendency. I got invited to the first Congress of the Polish judges, and I delivered a speech, and I heard the voice of the Polish judges, and there were 1,300 judges present on this Congress, and I was astonished at how much energy and how much willingness was expressed on this Congress. But no matter how strong the judges and how, I mean, they need outside help, and I think outside means, well, of course, political help from others, but judiciary should not be part of the everyday political fight in the country. I think we need an outside help. We have institutions. We have strong institutions, European institutions, European Court of Human Rights, Court of Justice, the Union Court, and also we have the EU, and probably the Parliament is the strongest possibility to raise their voice to, but nothing really has happened until now. Nothing really important has happened. I mean, probably it would have been better to intervene on some way to the Hungarian situation in 2012, or 2013. I think it would have been the best solution to immediately react to the situation. And of course, nothing really happened. I mean, of course, a lot of institutions dealt with the situation, but nothing really happened. And right now, this game inside the People's Party and the Hungarian Party, I mean, it's a never-ending game. Being part of the People's Party or getting out of the party or expelling Fidesz from the People's Party, I think it's a never-ending game. It's a political game. I think these judiciaries need some kind of help, and some kind of outside help, some kind of unified help. it's up to us. I mean, up to the voters to change the system if they would like to. But I think everything is very unequal, very unequal. Economic power, political power, press, an enormous press dominance. So it is. But right now, the situation is that some of the Hungarian leaders are expressly denying the separation of powers.
Yeah, and this was
the idea of separation of power, which was mentioned by Antonio Scalia, the most conservative judge of the U.S. Supreme Court.
I mean, this is exactly what makes the situation so worrying, that there is no realistic political way to change the situation anymore, because by means of changing the institutions and the procedures of democracy, basically all these options have been eliminated effectively. Yeah. And this leaves us in a situation where we have to take recourse to legal procedures, if that's true. And that means the European Court of Justice. Luxembourg Court has made some attempts already, as you have mentioned, back in, what was it, 2013 or something, up until this day. And time and again, we have seen the limits of the possibilities of the Luxembourg Court to intervene, partly because it takes the EU Commission to initiate an infringement procedure and to take Hungary to court, and they are unwilling to, for numerous reasons, most of them political. So what are your expectations with respect to the European Court of Justice? Is this, do you have hope that this will really have an impact ultimately? If not with Hungary, then at least with Poland? And if so, how?
Well, perhaps start a little shortly. Well, I think that the European Court of Justice always seemed to me quite a self-referential institution. I mean, they were very hesitant and somehow took some of the Hungarian cases with a very European Union way of attacking it, basically, not really kicking in human rights and not really taking the core issues as the part of the merits. And now they took the Polish question via, judicial independence and Article 19 and so on and so forth. And both case complexes somehow left the impression with me that they are mostly interested in a way in the integrity of the judiciary, without really looking at the political context and without really stepping in, basic, substantial human rights issues. And that means it basically looks like a court that is basically protecting its own turf. And therefore, I'm not really very, neither with regard to the CJU itself, nor with regard to the implementation of the cases in Poland, I'm not very optimistic. And I think the courts will not really solve. Courts will not solve or will not save courts, I think. Mm-hmm. And the most promising venue we have at the moment are basically the negotiations in Brussels about the conditionality of the rule of law program and the question of the budget. And it's amazing to see that basically many member states, and the most notorious case being Germany, are not making use of their immense power of the purse to pressure, especially Hungary, into some kind of commitment. In a way, pretending to be blackmailed by Hungary, while they are much less dependent on the money than Hungary is itself. So I think it's really much the most promising venue are rule power politics on the supranational level of the member states. And at the moment, actually, we would have a key to do that. It's in a way a rare opportunity that is we are now seeing. And I can say, as a German citizen, I can just say I feel it's quite painful for me to see how reluctant and somehow moderate the German presidency is with regard to that, and not taking responsibility for the whole. And this is the only thing that could work. While I don't really see the CJU doing much more than endorsing a finally quite formal idea of judicial independence.
Judge Guglielmi, what would your answer be?
I think that the European Court of Justice has made an important step towards the protection of the rule of law, ruling on the cases concerning the situation in Poland. And before this decision the European Court of Justice explained in important decision was the ruling on the Association of Portuguese Judges on 2018 that the rule of law is not an internal affair. So this is I think, the most important the key point when we discuss about the rule of law, to stress that is not a question of internal affair, or it is necessary that all European countries have the same standards of independence, and that the European institutions have the adequate mechanism to monitor according to this standard the level of the independence of the judiciary in Europe, and to react when reforms are not in line with this standard. So, in my opinion, the decision, the opinion of Medal, of course, the European Court of Justice dealing with the systemic crisis of rule of law in Poland has made very important steps towards a fixed notion of the rule of law and the European notion of the rule of law. It is of utmost importance that the European institution reacting to the situation in Poland has for the first time used the new mechanism, new framework to protect the rule of law. So I think we have made some important steps, and we need to continue towards this direction, because we need to understand that we cannot have a system, judicial system, which are not independent in Hungary, and different level of independence in the other European countries. So the European Union is based on the rule of law, and the independence of the judiciary is an important part of the rule, is a fundamental part of the rule of law, and that's why we need to ensure that the European jurisdiction and all judicial systems have some level of independence, some guarantees for the independence.
All right, thank you. Judge Bakker, what is your answer?
Yes, well, I see the role of the European Court, but don't forget that the European Court is based on the European law, and the European law, when it was created and the treaties were created, I think never really addressed the issue what would happen if there are countries which are on the margins of the European values. So European Court could play an important role whenever there is a very delicate question, but the European Court is not able to change structural problems of a country or of a judiciary. I mean, just to give you the Hungarian example, I mean, the retirement issue, the early retirement issue went to the European Court, reached the European Court of Justice, and they ruled on that. And they did it under the head of discrimination. Under the head of discrimination, because that was the only channel for the Commission to take the case to the European Court. And at the same time, when I had a discussion with the with the former president of the German Federal Court, he said, it's a shame it highly concerns the independence of the judiciary. I mean, the retirement age of the judges. And he was right. But the European Court was not able to handle this situation under the umbrella of independence of the judiciary because there is no European provision to do that. So they did it under the head of discrimination. And I think it's true. So European Court of Justice plays an important role, but the issue is much broader. It's much more. It's much wider. I think it requires political solution, and I think probably right now I don't have any other suggestion to take more seriously the budgetary issues. I mean the money. It's painful. It can be very painful. The issue is that to punish the government, but not to punish the people. This is the main issue, and I think it's a legitimate expectation. But something should be done because even the taxpayers of Germany, of the Netherlands, of the Scandinavians, and the taxpayers are demanding that, and it is legitimate to ask where the money goes and what's going to happen with the money. So I think it is also possible to generate the awareness of the public in those countries, telling and motivate them to tell their politicians to take serious steps to control the way of the money, and that's the only possibility what I see today.
Right. I do hope some German, Dutch, Austrian politicians do listen in and let themselves be convinced by these compelling arguments. Our time is up. Thank you very much for this, what I found a tremendously interesting and insightful conversation. I apologize for the sound issues we had. We had trouble with the connection. I hope you enjoyed the talk as much as I did. And see you next week with another episode of this podcast. Next week it's going to be about the prosecutors, about the public prosecution, which has also been the target of executive takeover attempts, and possibly a particularly threatening one at that. And this is going to be interesting, I hope. So have a nice day, and thanks to our three guests, András Bakker from Hungary, Maria Rosaria Guglielmi from Italy, and Christoph Möllers from Germany. And see you next week.